My name is Lieutenant Colonel Lee Roger Wolfgram, and I am a storyteller.
Welcome to the bunker.
Hey everyone, welcome back to the Colonel channel. This is an experimental AI episode because I want people to be aware of how powerful AI is. There is a huge dumbass in this video. I will let you decide for yourself. In this episode, I will refresh the Murdaugh murder case from the beginning, when Alex Murdaugh was accused of financial crimes through his police cam first interview, his jury verdict, and now jury tampering may get him a new trial. This story tells itself. You will be able to identify the dumbass. Let's jump in.
This whole scheme was about selling books, as you told Rhonda McElveen. If him being found guilty would sell more books.
I find that the clerk of court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity.
Facing several investigations against him in South Carolina, Alex Murdaugh is in jail in Florida. For now, his warrant was issued for a case under SLED, the South Carolina Law Enforcement Department. The SLED chief says this arrest in Florida is the result of months of work by agents, but not the end, saying in part, quote, "Today is merely one more step in a long process for justice for the many victims in these investigations." He goes on to say, quote, "We're committed to following the facts wherever they may lead us, and we will not stop until justice is served." His charges stem from suspicion of misappropriating settlement funds in the 2018 death of his family's longtime housekeeper. It's the latest in a string of scandals, including a shooting he survived but allegedly admitted was a conspiracy and is now part of an insurance fraud case. Meanwhile, an investigation continues into the murders of his wife and son. In a statement from Alex Murdaugh's attorneys, they say that he regrets that his actions have distracted from solving those murders. They say he will cooperate fully with the investigations against him. It is likely he will be extradited from here back to South Carolina, where he'll then likely face a bond hearing sometime next week.
All right, sir. I left the house without my watch.
12:57.
All right, Mr. Murdaugh, just state your full name for me, please.
Richard Alexander Murdaugh.
And spell your last name so I get it correct.
Murdaugh.
All right. And you go by Alec?
Yes, sir.
And date of birth, Mr. Murdaugh?
May 27th, 1968.
And a good phone number for you.
803-942-1227.
All right, sir. And sir, what was your name?
Yeah, Danny Henderson.
Okay. All right. As I stated, I'm David Owen in Lower Rutland with Colleton County, and I'm with SLED. I hate to have to do this.
I understand.
Yeah,
I totally understand.
Yeah.
So you don't have any problem with it.
So just start at the top. Take your time.
Like when I came back here, I mean, I pulled up and I could see them, and you know, I knew something was bad. I ran out. I knew it was really bad. My boy over there, I could see it was.
Sorry.
And I could see his brain on.
The latest on Alex Murdaugh. The South Carolina attorney has now been indicted on murder and weapons charges for the killing of his wife and son last year. Eva Pilgrim has the story. Good morning, Eva.
Good morning, George. There's a shocking twist in the South Carolina double murder mystery. The father, the husband, the once prominent attorney, Alex Murdaugh, now accused of shooting and killing his own wife and son. This morning, Alex Murdaugh facing charges, accused of killing his wife and son just over a year ago. On Thursday, a South Carolina grand jury indicting Murdaugh on murder and weapons charges, alleging that he fatally shot Maggie with a rifle and 22-year-old Paul with a shotgun.
Are they breathing?
No, ma'am. My wife and my son.
And what is your name?
My name is Alex Murdaugh. Please hurry. Neither one of them's moving.
The defendant will rise. Madam Clerk, you may publish the verdict starting with the back, not with the, let's see, I'll tell you again. Starting with the back, flipping them over one by one. State of South Carolina versus
docket number 2022 GS 15-00592, the State of South Carolina, County of Colleton, in the Court of General Sessions in the term of 2022, July, the State versus Richard Alexander Murdaugh, defendant, indictment for murder, SC Code 16-3-0010, CDR Code 0116. Okay. Guilty verdict. Signed by the forelady, 3/2/23.
Taking you straight to South Carolina right now, where lawyers for Alex Murdaugh are holding a press conference after filing a motion saying they've got new evidence.
If the Court of Appeals remands the case for an evidentiary hearing. We would also request that those in the media and the public respect the privacy of those included in this filing. Jim and I want to thank those on our team who stand behind us and have worked tirelessly to ferret out the truth. Alex Murdaugh maintained and still maintains his innocence in the murder of Maggie and Paul and believes the truth will ultimately prevail. Jim?
The right to a jury trial,
stand over here.
The right to a jury trial is a fundamental principle of our justice system. Jurors must be free from outside influences and must decide the case solely on the evidence presented in the courtroom, subject to the rules of evidence, subject to the rules of the court, and, most importantly, subject to the crucible of cross-examination that's guaranteed by the Sixth Amendment to the Constitution, and that is the right to confront witnesses. When jurors receive private communications outside the confines of a public courtroom, the Sixth Amendment is violated and numerous other constitutional rights are violated. And that's not Jim Griffin on the law, that is the law of the land. And I want to quote from a decision from the South Carolina Court of Appeals, which is behind me, and states this: where there is a private communication of a court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. A new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. What we had filed today, supported by sworn testimony of jurors, is that the clerk of court had improper private communications with the jurors, and the subject matter of those communications was the credibility of the defense that the Murdaugh legal defense team put up, and it was the believability of the defendant's own testimony. Now, there's been a lot of talked about whether Alex should have taken the stand. I can assure you, when we considered what factors and what we should and should not do and considered whether he should take the stand, we never considered the likelihood, as reported to us by the jurors, that the clerk of court would go in to the sanctity of the jury room before he testified and tell the jurors Don't be fooled by his testimony. Watch out for his body language. And that is what the sworn testimony that we have filed in court today says. And if that is true, which we have every reason to believe that it is, and no reason to believe that it's not, there's no choice.
Now, let's talk about this book for just a second. When did you first decide you were going to write a book?
I think a thought was there, a very fleeting thought, before the trial.
Did you take any steps before the trial or at the initiation of the trial to begin writing this book or working with somebody on this book?
Oh, no, sir.
When did you and your co-author get together?
It was several weeks after the trial.
Okay. Did you talk to anybody about the fact you were going to write a book before the trial?
There were several anchors and several journalists that I did speak with about the possibility of writing a book.
Now, also, during the trial, your daughter ended up on the Venari, is that right?
She did.
And she was coming up, and did you talk to me and Mr. Waters about putting her on the jury if at all possible?
I'm not sure that we wanted her to be on the jury if at all possible, but I think the question was, would she make a good juror? And I said she sure would.
Now, I don't think we asked you. I think you told us she would make a great juror, did you not?
I remember you asking.
Okay. I was considering putting your daughter on the jury.
Yes, sir.
You have described in your book your role as Switzerland, is that correct?
Correct.
Okay. And that is that you should not be in any way opinionated about what's going on in the trial, is that correct?
That's true.
Okay. Yet in your book you indicated a number of different points during the trial you had concluded he was guilty, is that correct? Let me give you an example. You indicate, riding back from Moselle, that you and 3 other people were in a car, and you all decided adamantly, I think was the word you used, that he was guilty, that he had killed his wife and son. Is that what you put in the book?
I can't remember if I put that in the book, but if you say I did, then I will agree with you.
Did that happen?
We did have a conversation about what each of us thought.
And all 4 agreed that he was guilty, correct?
And none of us were jurors.
No, trust me, I know that. But you had an abiding conviction, at least by the time of the Moselle visit, that he was guilty. And the other people in the car with you were bailiffs, were they not?
No.
Who were they?
Some were not bailiffs. One was a court reporter. One was our security officer, head security, and another was a deputy sheriff.
Okay. But the 4 of y'all rode out there, and based on what, and I mean, you want me to read to you how chilled you were and how you felt that poor Paul and Maggie had been executed by him on that scene, that visiting the scene convinced you that he was a horrible, horrible murderer? You want me to read that to you? Or you will concede that's what you wrote?
I will concede that's what I wrote, but if I may, I would say that a lot of that is poetic license in writing a book and in making it sound like that.
Okay, so some of it's poetic license, and some of it you just stole. You purloined it from that BBC writer, right?
Right, and I object to not only the relevance, but the scope of cross. I would object also under Rule 608. I don't believe that that's appropriate cross-examination.
Overruled. You may continue, Mr. Harpootlian.
Did you steal part of the book?
I did plagiarize,
Okay,
Mr. Harpootlian.
that's stealing, isn't it?
And it is, and for
Okay.
that I'm very sorry, and I have apologized.
Okay. And that makes it okay?
What I did, and I apologized for that.
And part of the book is, you say, literary license, exaggeration?
I wouldn't call it exaggeration.
Okay. Now let me ask you this, is Switzerland, and this is, you're saying this is happening while you're supposed to be Switzerland, you decided the defendant's guilty, and if Ms. McElmeen says that it's going to make you more money if he's found guilty, don't you think it's reasonable to assume that you may have crossed the line from time to time? Am I oversimplifying that? I mean, it's in your book. You saw something on Walterboro word of mouth which appeared to you to be from the ex-husband of one of your jurors. Is that correct? Am I oversimplifying that?
I remember reading one night something on Walterboro word of mouth, and when I was in the courtroom on a Monday morning listening to the judge and the attorneys talking about a matter, it sounded like it was relevant to each other.
Okay. And you became aware somehow that this juror had a restraining order out for her ex-husband?
She told me that herself.
Okay. And tell me how it came for her to tell you about that. Where did she tell you?
She was very talkative, and when I was instructed by Judge Newman to go and get her from out of the jury room with a deputy following me, she was talking to me all the way back to the judge's chambers, and she mentioned that there were restraining orders out when they had divorced.
So how did the judge, who brought it to the judge's attention about this Walterboro word of mouth thing?
I let the judge know, thinking that it could be related.
Okay, and you let the judge know what?
That I had read something on Walterboro word of mouth.
Okay, and that you knew it was tied to that juror?
I didn't know that it was. I wasn't sure at all.
Who do you think it was tied to?
From what y'all were talking about at the bench, I felt like I needed to let him know, just in case it was related. There was something about an ex-husband and an ex-wife and somebody being on the jury.
You didn't tell the judge that you had found what we call the apology post? You didn't tell the judge that?
I didn't call it that, no.
You don't remember producing it, saying that producing it to the judge, saying this is a post in which the guy that posted it on Friday night says the devil got in him and drinking and he apologized for what he posted? You didn't produce that?
My staff did, one of my staff
But you gave that to the judge and gave it to us, did you not?
Yes, we did.
As if it were from that juror's ex-husband, correct?
Correct.
And you know it wasn't?
I don't know that, Mr. Hartbulian, no.
So, and this, you did not take that juror out and talk to her before you took her to the judge? Is that
I never talked to that juror about stuff like that.
Okay. Did you ever talk to the forelady of the jury, separate from the jury?
I did.
Okay. And tell us, where did that occur?
When I would go into the jury room and I would speak with the forelady, we would be in like the hallway, in the two jury rooms were side by side, and the opening to the jury room went out into the hallway, and we would be surrounded by the jurors at all times. Mr. Bill would be very, very nearby, or another bailiff as well, when we would speak.
And what did you speak to her about?
There were several instances. One was there was a juror who needed some feminine products. There was another time when Band-Aids were needed. There were times when Tylenol would be needed.
Other than items that were needed by the jury's health object, did you ever discuss, did she ever discuss with you, if some issues jurors had emotionally or some issues with dissension in the jury room?
She only told me that there were some loud jurors, and it made some of the other jurors a little upset, but other than that, that's...
What did you tell her to do?
I told her if it got out of hand to write a note to the judge, and that she could sign the note and get Mr. Bill to give it to the judge, and the judge would handle that for her.
Okay. Now, you did publish a book after this trial, is that correct?
We did.
And you went to New York and took some of the jurors to the Today Show?
The Today Show did invite us, yes.
Now, one of those jurors that went up there with you, the day of the verdict, wore, for the first time I can remember, wore a suit.
Joining us now are jurors James McDowell, Gwen Jenneret, and Amy Williams. Good morning to all of you.
Good morning.
Thank you for being here after an ordeal, a 6-week ordeal. You did your jury service, your civic duty. You're here this morning. How does it feel when you realize all of the attention? You knew it was a high-profile case. Did you understand how many people across the country were watching this?
I don't think it ever really, hit that it would be this big.
Yeah. How do you guys feel?
The same.
Yeah, I didn't think it would be this big.
Me either.
When you saw the cameras outside the courtroom, though, I mean...
Yeah, that's when I realized this is a big ordeal, yeah.
What have people said to you just in the last few days? It's a small town. I mean, did they realize, you guys have been on the jury? Have you heard anything? What is the reaction you've heard?
So I think that, it kind of spread pretty quickly. So I think that a lot of my friends were very respectful. They didn't try to reach out. They didn't want to talk about the case because they knew I couldn't. Yeah. So I think afterwards, as soon as the verdict came out, everybody was kind of sending me messages like,
what's going on?
Yeah.
A lot has been made over the past few days about the speed with which you guys came back with that verdict. Take us inside the deliberation room. As I understand it, not everyone initially thought he was guilty. Is that right?
Correct.
That's correct.
Yeah, so throughout the case, a lot of people had talked about how we didn't have a notepad in the jury room, but we weren't able to have it in the courtroom, but we did have them in the jury room. So a lot of people would write down questions as we, went back during break. So I think that kind of made the deliberation a little bit more efficient. Everybody knew the questions they had. We were able to get through them quickly.
Yeah. Let's talk about the case a little bit. Everybody wants to know what you think. What for you was the critical piece or pieces of evidence, Amy, I'll ask you first, that made you feel confident that this guilty verdict was the right one?
Well, the witness testimony was very believable, and the kennel video definitely played a major part, and his testimony.
Yeah.
Yes.
Murdaugh's testimony.
Yes.
What about when there was throughout the trial, there were a lot of witnesses saying, that's him, that's his voice. When he got on the stand, Gwen, and said, yeah, that was me. What did you think? How did that strike you?
Well, first of all, I couldn't believe that he was taking the stand. And when he got on the stand, I was like, okay. So it was him. I don't know him, so I never, knew his voice, but I realized it was him. And in the kennel video, that just kind of sealed the deal.
Do you think he should have taken the stand?
No.
What about you, Amy?
No.
He didn't help himself?
No.
If I was him, I don't think I would have, but I think that he believes that he's so convincing that he felt like that was his, last resort.
The financial crimes, when the state introduced all of that evidence about the past financial crimes and the money he'd stolen from clients, the money he'd stolen from the firm as well, did that impact your decision at all? Did that make a difference?
Well, we could only consider it as part of the motive. It helped showing that he was very convincing and manipulative, and so it made sense.
Let's talk about his testimony a little bit more, because he was very emotional. People watching from the outside thought, maybe this will be compelling to jurors. Did you believe him? Did you believe his tears? Did you think he was crying? Some other jurors have said they didn't buy it. What, you're shaking your head.
No, I didn't think he was crying. He turned it on and off. Yeah, it wasn't genuine.
Do you think he hurt himself by taking the stand? Did he make it worse?
I think he did.
Yes.
Why?
I just think that, we already know that he's a lawyer. He's able to be emotional with cases. He's able to be emotional with himself. He knows, like what she said, when to turn it on and off. So I think that we were kind of able to read right through that.
After sitting there for several weeks, and again, the state didn't have to prove a motive, do either of you have any idea of perhaps why he did it?
I don't know if we'll ever know. I think it may have been a combination of things, not just the financial, but everything was weighing heavy on him, I believe.
Gwen, what do you think?
I think it was, he wanted to have control of everything, and his wife owned the majority of the things that they had. So I'm thinking it was more like greed and being in control.
I think the prosecution had a very good point. It's a storm.
Yeah.
At points in time, the defense would take one aspect and be like, it couldn't have been this. And it may not have been that one singular thing, but there's so many things there that contribute to that overall storm that, I think it played a part.
They had you guys go and visit the scene, Moselle, this estate where the crimes took place. Was that worth your time? Was that worthwhile? Did you learn anything from that, James?
Yeah, I think that we were, throughout the case, you kind of see pictures and stuff, but until you get out there, you're not able to really see how everything plays a part. There were a few things that I made mental notes of that I wanted to check out if we did go out there, and I was able to, take a look at that.
What about you, Gwen?
Same here. I wanted to see how big that feed room was, and it was very tiny in person. And I also wanted to see if you could see down there to the feed room, the kennels from the house, and you could.
I know two of you went back the next day after the verdict. You went back for the sentencing. Why was it important for you, the two of you, to be there for that part of it?
Just to see it through to the end.
James?
Just like what she said, you know, we spend 6 weeks there, we bond, we're a very close-knit jury at that point in time. So it was important for us to go back and kind of, you know, see it to the end. We had just decided what the verdict was going to be. We at least wanted to see it to the end, see what the sentencing would be.
Did you text, email, or communicate on the morning before final arguments were completed that to people that this was on a Thursday, that they probably, if they're going to see the trial, should come on that Thursday because it would be over by the next day? It would be, the jury would not be out very long. Did you ever communicate that? Email, text, or verbally?
I do remember saying that, yes.
And why did you think the jury would not be out very long? Had you communicated with jurors?
I had not communicated with jurors about anything related to this trial at all. I've been a court reporter for at least 14 years. I was clerk of court for 3. And you just get to where you kind of see things happen as they progress, and it's a guess, it's a gut feeling, and that's all that I meant by that.
Well, why are you telling this young man who wanted passes for the next day in an email, you know, it won't be happening tomorrow? That was or did you say, you didn't say, I don't think, you just said, you better come today if you're coming. Remember doing that?
I don't remember that. But, you know, if he wanted to come, I knew that the trial would be ending shortly as far as testimony. So if he wanted to come, he needed to come.
Why wouldn't the jury have been out a week on a 6-week trial?
They could have.
But
They could have.
you apparently were telling the press and others that it would be a quick verdict. Were you not?
That was just a gut feeling that I had.
Okay.
And that was my opinion.
Okay. Your opinion, you were right. The jury was out 3 hours on a 6-week trial, correct?
That's true.
How much money did you make off that book?
There was not a whole lot of money made off of the book after paying different things and paying for some expenses that went along with that. But I want to say roughly around $100,000.
Okay. That's not a lot of money.
No, especially when you publish your own book.
But that was $100,000 you made.
With my co-author.
Okay. In what period of time? 6 months?
I would say 6 months, yes.
When was the book published?
August 1st.
Okay. The trial was over. That's 6 months after the trial's over, you've published a book, correct?
Correct.
And then I believe you've recently stopped selling the book because of the plagiarism you've admitted to, correct?
Correct.
And so there's no more money?
Correct.
Now, you also indicate in the book that the Murdaughs had a reputation of criminality, I think, is kindly what you put. Did you not?
Well, Mr. Hartpooley and my grandfather and Old Man Buster were very close.
Well, were they criminals?
I wouldn't know.
You wouldn't know. But you believed and you published that the Murdaugh family had run that part of the state and they'd participated in criminal conduct, correct?
Your Honor, again, I would object to general testimony about the alleged criminality of this family. I'm not sure how that has any bearing on the focused inquiry before the court.
He's asking about what she said in the book. I'm going to allow it.
Yes, sir. Did you say that in the book, that they were criminals?
In the book, that was more of the literary ease that we take, I think, to make a story a little more interesting for the reader.
By calling people criminals. I guess what I'm saying is this. Were they criminals?
Your Honor, again, I object to that particular question.
Overruled.
Were they criminals?
I wouldn't know that.
Okay, so you either made it up or you're lying about it? About the reputation of people that can't defend themselves? They're dead? You're going to call them criminals? You did that in the book so you could sell a book?
No, I didn't do that to sell a book.
What'd you do it for? Made it more readable, you said? Which sells books?
Literary ease. Yeah.
What?
Literary.
Literary what?
The literary ease that you can take with when writing a book.
Literary ease you can take with writing a book? You can make stuff up? You can lie? You can lie about people?
Not with that. I think the public perception was one that it was very interesting during this time.
So you're feeding the monster out there that wants to believe bad things about the Murdaughs, and you'll make stuff up to do it. Let me give you another example. I read your book, and I found this somewhat humorous. My co-counsel did not. In describing myself and Mr. Griffin, in the book you say that I neutered him. We've both been very interested in what you meant by that. What do you mean by neutering Jim Griffin?
Mr. Hartpoolian. It was a book.
Did you make it up? I know it was a book. The Bible's a book. Right. Just because it's a book doesn't mean you can lie in it.
It's just a word that was used.
The nature of that exchange.
Don't argue with the witness, but the witness, Ms. Hill, you're instructed to answer his questions. You may proceed, Mr. Hartpoolian.
So let me get this straight. The book, and I'll see if I can cut to the chase on this. I could read you chapter after chapter, verse after verse, which is not true. Okay? Not true based on my experience of being in a courtroom, and not true based on knowing some of the people you describe. You say that is...
Mr. Hartpoolian?
I object. The counsel's just testifying right now as to his observations about the book.
Question, Mr. Hartpoolian, please.
You've conceded there are things in the book that you don't know to be true, correct?
Correct.
Okay. You would concede then that you have lied in the book.
It's only because I wasn't there at the time. I can't interview my dead grandfather. I can't interview Mr. Buster. There's just things that we can't interview them on. We can go by what was written in a newspaper and get facts from that.
And take the inference that one of the Murdaughs was a pedophile. You could have printed that, and they're not here to contradict it. You could have printed anything you wanted and made it up to sell books. That's what this... But you do concede that Netflix did get sealed exhibits.
They did it as an error. It wasn't
Whose
listed.
error?
Well, I would say the court reporter didn't mark it on the listing.
Well, why were you so accommodating to these national documentary folks? Is this good for the book? The more documentaries out there about the Murdaugh thing, the better your book sales are. There was money in this for you, right? Again, it's about the money, right?
What's your question now?
Isn't it financially beneficial to you at the time to get more of these photographs out, more publicity, more Netflix, more HBOs, more Japanese? Doesn't that sell books for you? Didn't you see a financial advantage?
Not at all.
Okay. Thank you. No further questions.
Was your verdict influenced in any way by the communications of the clerk of court in this case?
Yes, ma'am.
And how was it influenced?
To me, it felt like she made it seem like he was already guilty.
All right, and I understand that's the tenor of the remarks she made. Did that affect your finding of guilty in this case?
Yes, ma'am.
Juror Z, I asked you previously, was your verdict on March the 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court? You answered that question, yes. In light of what you said in the affidavit, which is I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Is that answer that I just read a more accurate statement of how you felt?
Yes.
Your Honor.
Overruled.
Yes, ma'am.
All right, so you do stand by the affidavit?
Yes, ma'am.
Very good. Thank you. Mr. Harper.
Your Honor, we objected to the questioning because this juror gave two statements under oath, one in an affidavit and one here to you today. The one here today was Becky Hill influenced her verdict.
Yes.
The one she gave in an affidavit 6 months ago was based on jurors. It could be both. Your Honor picked out the one in the affidavit from 6 months ago and said, is that a more accurate statement? That presupposes and suggests to her what she should say. And we believe that this juror's testimony, and Your Honor, I'm afraid what you're going to say is, well, she said the affidavit was more accurate than what she testified under oath here today, and therefore I'm not going to consider her testimony. And I think that's where we're heading here. I'd ask you to bring her back in, explain to her there's nothing wrong with it both being true.
I decline to do that and overrule the objection. I have a communication from Mr. McCullough.
The 19 today.
That's only, that is copied to Mr. Harpootlian, Mr. Griffin, Mr. Waters, and Attorney General Wilson. And basically, it says his client, Juror Z, wants to enhance the testimony she gave with some sort of affidavit that he wants me to look at, and I have looked at it. I want to hear from the state and the defense, but I can tell you I'm not inclined to get back into the testimony that's already been taken by these jurors. Her inconsistencies, whatever they are in the record, and she now wants to have another bite at the apple. I'm not at all enthusiastic about that.
Joe McCullough has issued this statement to Court TV. After the questioning of jurors today, I spoke with my client, Juror Z, and we were concerned there was a lack of clarity from her testimony created by an incomplete affidavit from several months ago and the progression of questions asked in the hearing. To add clarity and protect Juror Z from accusations of inconsistency, we prepared an affidavit detailing that she felt influenced by both comments made by the clerk of court prior to deliberations and pressure from other jurors during deliberations. Today's affidavit was then submitted to the court, the state, and the defense, and it is my understanding that it's been filed with the Supreme Court as a part of the record in this case.
This whole scheme was about selling books. As you told Rhonda McElveen, if him being found guilty would sell more books.
My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the clerk of court, Rebecca Hill, to a juror or jurors, and two, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influenced the juror to vote to convict Defendant Murdaugh. The facts. Did Clerk of Court Hill make comments to any juror which expressed her opinion of what the verdict would be? Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the Clerk of Court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the Clerk of Court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. Did Clerk of Court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. 11 of the jurors very unconditionally said They either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit, in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations. But the juror was somewhat ambivalent, said on her oath at the time of trial twice, and said on her oath before me in these proceedings that she stood to her oath. I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity-influenced clerk of court. This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied.
I am ashamed of the legal system in this case for many reasons. This episode has been created using AI to depict an avatar of myself. Let me know your thoughts and be sure to subscribe. Until the next time, Wolf 6, over and out.